Yes, Preston, in that report of the 408 sexual assault victims and their cases studied, 60% of those ended up with the perpetrator pleading down to a lesser charge, like a misdemeanor or a non-sex offense.
We're here to say to them that we acknowledge this happened. This is serious, and we do believe them.
Since 2021, the King County Sexual Assault Resource Center, or KSARC, has been tracking hundreds of sexual assault cases and their outcomes, finding the majority of those cases resulted in the accused getting a plea deal for a lesser charge.
When a case is pled down, the victim feels as though they've not been acknowledged. Their experience has not been heard.
KSARC says this can also mean victims who sometimes wait years for a resolution can be left without a sexual assault protection order, and the accused doesn't have to register as a sex offender. But King County prosecutors say they need to consider the needs of the victim, the safety of the community, as well as the rights of the defendant and the evidence when making these decisions.
One of the primary things we consider is what is the strength of our case, and how does the strength of our case and where this case should go measure up against what the victim wants.
Prosecutors say they consult with the victim and negotiate plea deals mainly due to evidence, and often helping the victim get a protection order can be part of that deal.
The cases that we resolve because we feel that that is the right thing for the case. Sometimes it is because it is the best thing for that victim, and the defendant is willing to take accountability in that measure. And when those two things align, we offer those opportunities.
Let's center the victim's experience. Let's look at the victim's voice in this. Let's make sure that we're including their input.
And KSARC says they continue to work with the prosecutor's office to make sure victims are at the forefront and resources to help victims continue to be funded. Reporting live in Seattle, Lynn Ann Wynn, KOMO News.